moving on, in a major victory and a crucial verdict, the Supreme Court today quashed the Gujarat government's decision to prematurely release 11 convicts in the Bilkis Bano case. Bilkis Bano was 5 months pregnant when she was gang raped. Her 3-year-old daughter was among 7 of her relatives who were murdered during the post-riots, which left around 1,000 people dead. Bilkis Bano and her husband were not in her village on the day of this crucial verdict. It appears they left the village due to safety concerns. But what did the court say? The court said Gujarat was not the competent government to pass the remission order, and that the 11 convicts should return to jail within 2 weeks. The court observed that the convicts had misled the top court to rule that the Gujarat government has jurisdiction so that they could obtain the judgment fraudulently. It further said that Gujarat government usurped Maharashtra's jurisdiction and that it was the state of Maharashtra that had the power to decide on remission as the trial was conducted in Maharashtra. The Gujarat government had justified the release of these convicts, stating that they followed the reformative theory.
It's an extraordinary judgment because the court has set aside its own previous judgments. And I would say classically it has done what we call justice.
So there was one more observation by Supreme Court regarding the 1992 remission policy, wherein we can see that Gujarat High Court has backed it and given the accused whatever the benefits which they have got. How do you look at it?
Okay, so see, there was a policy of 1992 in Gujarat, replaced of course subsequently by another policy. But the court, I think, is referring to the policy in the state of Maharashtra, which came before the conviction took place. Now the relevant state is the state of Maharashtra. The relevant policy is the policy of Maharashtra. And Maharashtra did have a policy which said in cases of violence against women, especially rape, there should be no remission. Because see, after all, they were convicted for life. Right? And they were just applying to be released after 14 years. And much of this 14 years was spent on parole. But it's up to the government to decide whether to give it or not. In consultation with the trial court, in consultation with the investigating agency, which in this case was the CBI, and all of them said, no, don't grant it, because the nature of the crime is gang rape in a situation of communal violence. So don't give it. And yet, they went behind the back of Maharashtra government. They went to the Supreme Court. They went to the state of Gujarat and it was given. So the court says this is a question of usurpation of power by the state of Gujarat.
At present, I'm in Devgarh Baria. Now, this is the rehabilitated village of Bilkis Bano. Basically, she stayed around 50 kilometers from here, but after the riots, her entire family members who remain and also the villagers were shifted over here. This is the residence of Bilkis Bano. She stayed here for 1 year. Unfortunately, because of security reasons, she had to shift base as well. Now, with me is the brother of Bilkis Bano. कैसे देखते हो ये इसको moral victory मांगते हो? और एक कड़ी तरीके से निशाना भी साधा है सुप्रीम कोर्ट ने. वो कॉन्विक्ट्स को बोला है कि तुमको वापस जेल जाना पड़ेगा, 2 वीक का समय है तुम्हारे पास, और ये एक सेटबैक भी है गुजरात सरकार के लिए भी.
सुप्रीम कोर्ट ने जो आज चुकादा जो दिया है, जो मीडिया के माध्यम से हमें पता चला कि उनको उन दोषियों को दोबारा मतलब जेल भेजा जाए और 2 वीक के अंदर जल्द से जल्द उनको जेल के अंदर डाला जाए. और हमारे सबकी यही राय थी और मतलब हम सुप्रीम कोर्ट के बहुत बहुत आभारी हैं.
सुप्रीम कोर्ट से और देश के सर्वोच्च अदालत और न्यायतंत्र पे हमको भरोसा था कि हमको जरूर न्याय मिलेगा और आज मीडिया के माध्यम से जी आप सुन रहे हैं, इससे हम खुश हैं.
Right, and I'm being joined at this point by Kapil Sankhla, who's a lawyer with the Supreme Court. Thank you very much for joining us. My first question to you, this even Indira Jaising has said is an unprecedented judgment. It's a very crucial judgment. How do you really look at the nuances of what this is? The very fact that the jurisdiction of a government has been questioned, a government who has a lot of legal advisors with them as such, it's a state government, their jurisdiction itself is being questioned. How important and significant would that be?
I'm sorry, but why can't I hear you?
Mr. Kapil, can you hear me? Mr.
Am
Kapil?
I audible? Because I can't hear you. Is there some issue?
Yes, I can hear you if this issue can be resolved. And while my
Is
team
there a
tries
question
to
towards me?
fix
Because I
this,
couldn't hear
let's
you.
just also just revisit what has happened. Yes, Mr. Kapil, can you hear us?
I can hear you. Yes, please. What was the question?
Okay. Yes, Mr. Kapil, just to break down and try to understand the nuances of what has happened, the very fact, the heart of this judgment, there are so many things. First being, the very jurisdiction of a government has been questioned. And a government has clearly been told that that's not your jurisdiction. It's not the Gujarat government's jurisdiction. It's the Maharashtra government's jurisdiction. Just to
Right.
try and understand legally, is this usual? Is this usual for someone to overstep one's own jurisdiction in such a sensitive case?
Well, it's quite an interesting matter because this is quite a legal seesaw that has taken place. You see, before I answer this question, you will probably be surprised to know that the jurisdiction of Gujarat government came from an order of the Honorable Supreme Court. And therefore,
Absolutely.
what is being said as the jurisdiction having been usurped actually came in terms of a direction of the Honorable Supreme Court itself. Now it has been said that the said jurisdiction was usurped by non-disclosure of material facts by the accused who are in this matter, and that also the Gujarat government did not file a review petition, thereby supporting the accused. So when I said it is quite a seesaw, it is because of this, that you're absolutely right. This is one of cases where the jurisdiction of the court to deal with matters such as this has been decided. And the jurisdiction comes like this, that the matter was in Gujarat, it got transferred to Maharashtra. In Maharashtra, it went all the way to Mumbai High Court. The accused moved remission before the Gujarat High Court. Gujarat High Court rejected it. They went to the Honorable Supreme Court. The Honorable Supreme Court stated at that time that Gujarat government did have the jurisdiction to decide on the remission. Thereafter, the review that was filed was also by Bilkis Bano was also rejected. And thereafter, now in this present petition, now in January 2024, the Honorable Supreme Court has made three material observations. One is as far as the jurisdiction is concerned in cases such as this, saying that the court that took care of the trial is the court competent to decide on the remission and not where the, so to say, the case took place, etc. That is a material fact. The second important thing that was decided
Advocate,
today,
let me just interrupt you before you go on to the second point, Advocate Kapil. There's also another layer to this, and very closely with the jurisdiction is also this whole thing about a reformative theory of punishment vis-a-vis the women's right. And in this case, we were talking about a woman who was not only gang raped, but her family members were brutally killed before her. And this was, this was absolutely proved in court. The convicts are those in this case who have been convicted of this crime. And yet, you saw a debate here unfold about how either it be the government, Gujarat government, or the convicts in this particular case who try to hide evidence to fraudulently claim a particular kind of a verdict. How huge is this?
Well, this is very huge, but let me also talk about the law in this matter. See, what had happened was that there was a 1992 remission policy of the Gujarat government. They sought to take benefit of the remission policy of the 1992, which was only available for convicts or cases in Gujarat and not outside. So therefore, as I said, that though at the first instance the Gujarat High Court had rejected it, but they went to the Honorable Supreme Court in 2022, the same was permitted and they came back and then took benefit of the 1992 remission policy. What was not disclosed were twofold. One, what was not disclosed is the 1992 policy already stand exhausted and that benefit could not have been taken by them. That's one. The second, what they did not or fraudulently disclose was that there were two contradictory stands in the Mumbai High Court as far as their case was concerned, and they sought benefit, saying that since there is a contradiction And two different views, therefore, under 32, the Honorable Supreme Court should look into it, in terms of which the Honorable Supreme Court had passed the 2022 order directing the Gujarat High Court to decide on that matter. So, the Honorable Supreme Court now, in January 2024,
Advocate, just as a very
rightly
lay
stated
person
two
for me to
materials
understand,
three materials.
for such omissions, you know, it's even hard to say omissions, for such loopholes to then become ingrained in a system where no one even challenged it, the government did not even challenge this thing which came forth from the convicts. Isn't this huge and something that should not really be taken light? In fact, the Supreme Court, I mean, I'm no one to say this, but this should not also become a precedence, because this, as a layperson, really seems as a convict and the government perhaps were hand in hand, because if the convicts did try to mislead it, why did the government not try to bring in another interjection? Legally, how is this looked at?
Well, in deference to the Honorable Supreme Court, you are right that the Gujarat High Court did not file a review petition. But in deference to the Honorable Supreme Court, Bilkis Bano had filed a review petition which had got dismissed, challenging the 2022 order. So therefore, I mean, rightly or wrongly, let us be fair here, that the review petition had been filed regarding the 2022 judgment, which had been rejected by the Honorable Supreme Court, and review petitions are rarely filed or rarely entertained. Should the Gujarat government file the review petition? Definitely yes, because that is what state governments and government does. And they have no loss of funds, they have deep pockets, so they should have. But the second aspect, as I said, deference to the Honorable Supreme Court, is that Bilkis Bano had filed the review, and that review was brushed aside. And therefore, that order of 2022 still was good law. The Honorable Supreme Court now has stated that that is per incuriam and a bad law, because it was actually decided or granted on basis of material fraud committed by the accused. But the fact does remain that Bilkis Bano had challenged it and had got rejected. And therefore, you know, as I said, it's quite a seesaw of judgments as we see as on date today.
Right. Right. Thank you very much, Advocate Kapil, for joining us and trying to explain the legal nuances to us. What is really difficult to fathom is that how could a government's policy, which is exhausted in terms of remission, be quoted before the court as a basis for 11 convicts to get their remission or their premature release from jail? That is, even as the victim in this particular case, or the survivor and her husband, have been shifting base, have had to move out of their village because of security concerns. And remember, this is one woman who was not only gang raped, which itself is heinous, but she's seen her family members being butchered and killed, including her daughter, right before her eyes. For now, the 11 convicts are going to go back to jail.